Now, I had the last session, the hippopotamus session before lunch. Now I've got the bloodless session, the session after lunch. I don't know whether you experience the same as me, but basically there's only a minimal amount of blood in my brain now because it's now all in my stomach. So it went down, but I can make that work in my favor since it's going to be the same for you guys. So I can get away with more. I want to speak about a very legal topic now that, well, is a battleground for lawyers. I would even say that it is one of the most important issues featuring in legal disputes about public procurement. And that's the whole issue of coverage and scope. Yeah. Coverage, you know, like I put here the foliage from autumn, you know, like it's covering the ground as a background here. And when a lawyer talks about this, no, really difficult to move these slides. Really? No. Why did this not work for me? I did this too. No. Okay. Right. Okay. I have to make a selection of these slides to explain what this is about. So essentially, a first reaction from a lawyer, be that in a contracting authority or be that already when it's coming to litigation. Yeah. So you get lawyers involved in two ways. One, when it's already litigation, so things have already gone wrong. And then you need them to help you with the litigation, to represent you in court and to advise you on how to go through this in court. Or if you exactly want to avoid that, so you bring them in before it even gets to court. And the first thing they will ask is, what are the rules? And the second question, and that's the question I'm dealing with here, is, do we actually have to follow the rules? In other words, do all these detailed rules on procurement law actually apply to this contract, to this situation? And when it comes to scope, to the question of, is my situation actually covered by the rules? Do the rules cover my situation? Is two different questions. The first one is personal scope. And here we're actually looking at who is buying, who is procuring. This is all about the question of whether the entity I'm facing, I'm dealing with, is covered by the rules. Broad question is, I will explain this a bit more, but broad question, is this unit that is buying really part of the public sector? Is this really part of the wider government? And when we answer that question with no, we are already out and you can finish. And the whole problem is looked at from a completely different angle, not from specific procurement law. If you answer the question of are we covered personally as an institution with yes, then you have to go to the second question of material court. So we're no longer looking at the institution, but we are looking at the contract. And we have to ask whether the type of contract in front of us is actually covered by the rules. Now here I'm making a bit of a selection. So don't get worried when I basically move across a couple of the slides that are a bit more about UNCITRAL and GPA. So in order to basically use the time best, I'm concentrating on the EU system. And here it's all the question of first, are we covered by one of the directives? And there are 6 directives altogether, but there are 4 substantive ones. 4 directives that actually regulate the public procurement process. The other 2 are only about litigation. Yeah, the so-called remedies directives. They do not regulate the procurement process. They regulate what is happening when the procurement process did go wrong or did allegedly go wrong. Yeah? So we've got the main instrument, the Public Sector Procurement Directive 2014-24 for the public sector. The whole question is, what is public sector? We have a utilities directive, which is dealing with procurement from utilities, generally speaking, a more flexible regime. We have the concessions directive, which is dealing with a very specific type of a public contract, which we will not go into here, that I'm now limited to 30 minutes. No way I'm going to speak about concessions, not one of my favorite subjects anyway. And then we've got the Defense and Security Procurement Directive, which is one of my favorite subjects, but I really don't have time to talk about that either. Here, this is kind of a self-contained regime. The remedies part is not in a separate directive, but already kind of merged with the substantive part. So the remedies for defense are already in that one. So various questions arise. Here is, am I covered by one of these directives? And if I'm covered, which one? Yeah, so this is already an issue. And actually, the question is not really whether I'm covered by one of these directives, but am I covered by the national law that transposed this directive into the national law of one of the 27 member states? So that is what people are dealing with. For example, let's say, for example, in France, they're dealing with a specific code that transposes these directives into French law, not with the directives directly. Okay, then. So I'm not going to speak about these directives. Question 1, which purchases are covered? Question 2, which contracts are covered? Now, most of what I'm talking about is about the public sector directive. The directive covers contracting authorities. And when you, especially the non-lawyers, who at some stage will have to go through that difficult moment and actually open these directives and actually start reading them, I can see the fear in your eyes, but you just have to face this. You're not going to get around this. But what you will see is actually first a huge preamble with like 100 paragraphs, you know, telling all the things that actually the EU wants to achieve with this new legislation. Yeah, you get a lot of definitions. So that's basically almost like a little catalog of things what actually specific terms mean. And then you actually get into Article 1, and Article 1 is together with Article 2 is already talking about the type of entity, procuring entity, that is actually covered by this specific directive. Yeah. Now, the coverage is the same for all member states as far as the abstract definition of a contracting authority is concerned. Yeah. Individual member states are not allowed to have individual definitions of the term contracting authority or public authority. It's all the same definition. However, how then we try to make this more workable is that, in addition, very bad news, but hold up, you don't just have abstract definition of what a contracting authority is. You also have then annexes after. So it's not just the preamble and the actual body of the directive, but then you've got annexes as well. A monstrous number of annexes. And I'm just warning you, because you don't need to know all the details about the annexes. Yeah, you rather have to learn to look for the things that you really need, and most of the stuff is really stuff you never deal with. But there is a nice annex there, and one of the annexes has a list of contracting authorities that are covered by the directive. Yeah, so for example, for Italy, it will list the Office of the Prime Minister, and it will list the Ministry of the Interior, the Ministry of Defense, the Ministry of Finance, and it will then go into the regions, and the city of Turin will be there, and it's basically listing them. That's quite nice. And when you're on the list, you're definitely covered. Okay. If you're not on the list, that doesn't mean you're not covered. because you could still come under the abstract definitions. They try to bring this in line, but it is not always 100% in line, which means you also need to know the abstract definition. What is a contracting authority? It is something that covers the state at the central level. And then below the central level, if it's a federation, the states that make up the federation, or regions, provinces, and then further down, local authority, like, for example, the city of Torino. And then down, in principle, down to the very last village in which you only have a part-time mayor, yeah, who's also a farmer or a butcher and is doing about 3 hours of mayoring every evening. Even he or she is covered by the rules. It goes all the way down. That all these are bodies. And you then have, and this is quite easy to handle. The next point then would be bodies governed by public law and association formed by such authorities. So, sorry, why is this important? It's important because it also answers you the question, what kind of authority actually has to apply the nice rules that promote sustainability? Yeah. So, what is a body governed by public law? According to Article 2, paragraph 4 of the Public Sector Directive, it has legal personality. It must be set up to meet needs in the general interest. It refers to bodies which are mainly financed or appointed or controlled by other contracting authorities. These are ors, not ends. Yeah? And they must not be of a commercial or industrial character. Can you see how, if you perhaps have not a listed body, how a lawyer would already make this a major issue in order to perhaps bring a body that he or she is advising out of the set of the rules? The price is not to be covered by the rules from the perspective of the lawyer who advises a contracting authority. So, however, that is not the main interesting issue. The main interesting issue is actually what types of contracts are covered. And this is a bit more complex. Here, we will not have a list. Here, we have some abstract definitions, but and a couple of concepts, and they have to be taken into account. So first is what is a contract? In the sense, it's basically a contract in writing for pecuniary interest, which are either public works contracts, public supplies contracts, or public service contracts, which have a value above the respective threshold and are not expressly excluded. Yeah? So, I must have a contract in writing. Yeah? Not something, oh, but we agreed on this over a beer in the pub. Yeah, oh, it's all happening. It's all happening. I'm not making this up. For pecuniary interest, what does that mean? It means there has to be Latin do ut des, synalagma. Yeah, I give to take. So somebody has to pay for what is given in one way or another. It cannot be given for free. It cannot be gratis. Okay. Yes. Okay.
What about this procurements for €0 that we're recently hearing? Is that fulfilling the pecuniary interest standard?
Probably not. Probably not. €0 is not a pecuniary interest. It's for free. Yeah. And then we move on to two very important points about which I have to speak a bit more. Yeah? Basically, look for a payment. Look for something written. Yeah? Look for something that is works, supplies, or services. And then have a value above the respective threshold and are not expressly excluded. Something I want to talk about here. Thresholds. Yeah? or perhaps first I speak about what is actually meant by. So we have here, the mother of the procurement contract is the works contract. Works is already an EU term, perhaps most would say a construction contract. Yeah? That's how the first procurement laws were about construction procurement. Bridges, schools, yeah, fortifications, a new prison. Yeah. We then have supplies contracts. That's about the acquisition of a product, obviously. Okay. Purchase, lease, rental, or hire purchase. So that would be ranging from a computer to a battle tank to ambulances, desks, whatever. And then the service contract. And in a way, the service contract catches everything that is left over. Yeah, if it's not a supply contract, if it's not a construction contract, it's probably a service contract. That you know, somebody's doing something for money. If it's not works or supplies, it's services. So everything gets caught in the end. Now, and this is important to be aware of, because it kind of already limits, to a certain extent, separate question actually, what we can achieve for sustainability through procurement. Our directives, so for example, the public sector directive, according to its Article 4, you see this is at the very beginning. Overall, the directive has just over 70 something articles. So all this about coverage, what I'm talking about, is at the very beginning. And what we have there is thresholds. So actually, based on the estimated value of a contract, the public sector directive only applies above certain value thresholds. These are quite common. So for supply, so let me take the works one, because that's kind of in your face. So the public sector directive, meaning the densely regulated rules of the EU on procurement, only apply to a works contract above the value of 5.35 million euros. Yeah. Only which, well, I give it to you whether that's a lot or not. Yeah. For any major infrastructure product, 5 million is nothing. But for perhaps the construction projects of even a smaller municipality, that's a lot. Yeah? Meaning, if that municipality builds a new primary school and that costs, let's say, am I completely unrealistic, or perhaps something like 2 million euros? Yeah, is that about right? I think it should be. That would not be covered by the directive. Yeah? So a lot of procurement is actually happening to which the rules, by the way, the principle of threshold applies almost everywhere. Yeah, so this is not just unique to the EU system, the thresholds are just different. So that actually a lot of procurement happens below the thresholds and is not at all covered by the rules, at least not by the detailed rules of the directives or the transposing laws. Of course, when now a member state like Italy goes and takes this public sector directive and transposes it into its national law, and it becomes then, don't know what it's called, the Italian Procurement Act, they can say these thresholds don't matter. We will have the rules much lower, applying much lower. But that would be not something imposed by EU law. It would be something that the Italian legislator takes him or herself. Right. For supplies and services, we have that threshold at as low as 139,000 euros for central government and 214,000 euros for non-central government. Yeah. Now, for central government, now here the story is a bit different, yeah? For central government, 139,000 is Not a lot, yeah. So their activities in the supplies and services sectors are to a large extent covered by the rules. Yeah? Whereas for works, very high threshold, there can be a lot happening below. Which doesn't mean that, to speak again about that little municipality with a part-time mayor or mayoress, 139,000 is already so high. Sorry, and actually for them it would be 214,000 because they're only a municipality and below the national level. They probably can do their procurement without applying these rules. Yes? So for example, in Italy, you have a central government in Rome, and that will be covered by the 139,000. And then there is here in the region of Piedmont, there is a regional government, and then there are provinces as well. And then there is a local authority just for the city of Turin, and all this is subnational. And they would have then the higher threshold, meaning the rules only apply from a much higher threshold. Yes, yes. Yeah, and it depends entirely on how the country is organized. Yeah, Germany is a federation made up of 16 states. There is a large federal level, which includes armed forces, for example. But actually, many people don't realize that from the outside, most government activity is not actually done in Berlin by the federal government. The federal government is actually not that powerful. Most activity, schools, universities, prisons, police, construction, all these things is actually done at a state level. Yeah, so here we would actually be talking about that would be a lot, that would be the higher thresholds, which would already happen at this rather important level. And then below that there are districts, and below that there are local authorities. So it can be quite elaborate in the build-up. Yeah.
Because I think this is interesting. And then if you look on other hand side within Denmark, you have a procurement system fairly centralized. So a lot of procurement done for whole state is done by some central purchasing unit. But then you have different sectors such as universities, healthcare that is done by regions. And then, for example, kindergartens or elderly care is done on very municipal level. So it's sort of how public tasks are distributed and then on which level you buy. Does that make sense?
Mm-hmm. Perhaps I could add my last slide. So I'm sorry, I'm switching around a bit because this is connected to that. Because there has been, the question then is, what happens legally to contracts below the thresholds? I'm sure you'd be interested to know, because otherwise quite a lot of procurement will already be included from its use for sustainability. Now, the directives do not apply. It's already a very important issue, although there have been member states who decided that's exactly what they're going to do. They are going to apply the directives to all their procurement. So they're going to ignore the thresholds and make their laws apply below the thresholds. But these were always decisions imposed by national law. Yeah, so in Austria, you have the mirror principle, where the principles of the directives are equally applied below the thresholds. Why? Because bidders protested about being unequally treated. So bidders for contracts below the thresholds were protesting about being treated unequally in comparison to bidders above the thresholds, where the full remedies directives applied, and that violated the Austrian constitutional rule of equal treatment and access to justice. Yeah, so it's nothing to do with the EU. The EU basically, at least until recently, was not worried about access to justice. That's not what it was about. It was about opening procurement markets. So the decision to lower the thresholds quite substantially was until, I think, about 10,000 euros. Below that, it becomes bagatelle. It becomes like a small fish. was an Austrian decision. But the fact is that the Court of Justice has, well, almost answered the question of what system should apply below the thresholds. Because while the directives don't apply, the treaty still does apply. Yeah? The treaty, and it has decided in seminal decisions from Denmark, the Storebælt case and the Unitron Scandinavia case and the Tele Austria case, that basically certain rules come from the regimes of the treaty on the free movement of goods and services and apply to contracts even below. That means you cannot discriminate against bidders from other member states, even for small contracts. There has to be a certain minimum level of transparency. Doesn't mean that you have to advertise on the tender portal of the EU already. That is, although that would be the safest way. You can also advertise elsewhere, for example, in your national gazette or in a newspaper, as long as there is fair transparency. And procurement decisions, even those below the thresholds, have to be reviewed, meaning a bidder must be able to take a contracting authority to court over it. But of course, this is a lot more flexible, low touch, when you compare it to the very detailed rules of the directives. Yeah? But it is a battleground in itself. And that, of course, then opens the question, what happens with the whole sustainability regime below the thresholds? Yeah? Right. Yeah. Okay.
The Commission on the implementation of best practices is May this year, and there is an hilarious table number 1 at page 8. Austria, report not submitted. Belgium, not applicable. Germany, not applicable. A lot of member states, they don't even thought it necessary to send the raw data to the Commission. Is one challenge you will have? It will be to find meaningful data. And I had, no, it was with Jadun. Ages ago, I had a trip to Brussels and spoke with someone in DG now market about procurement data, and he just told me member states, they just tell us a lot of, well, it used something different, but it was not recorded, so lies. It is really very difficult to find data, and the TAD is a place where you can find some data, but good luck.
Okay. Yeah, so apart from not applying below certain thresholds, this is imperfect as well, and it doesn't always work very well. That's for sure. Okay, one of the tricks, and this is just a little detail, is that there have to be rules for a certain tendency of some contracting authorities who do not want a contract to be covered by the rules, and therefore take a bigger contract that is with its overall value above the rules and split into smaller pieces, so that then perhaps the one big contract is split into 4, and that the 4 pieces then are all below. And there are specific rules, maybe not so successful, but there are rules and directives as well that prohibit that or limit that. Yeah? So this is already, you can see how you can play with this. And how important it is for you as a contracting authority. You are in charge of a contract, and your boss will ask you, do the rules apply? So that's the first thing you check, one of the things you check. I'm running out of time, but in addition to contracts that are outside the directives, because they are below these threshold values, right? The directives or any procurement law can also include, no, the word include is not really the best here, can also insert exceptions, meaning it can say, irrespective of whether that contract is above the threshold, even a contract that is above the threshold is hereby, by our political decision, expressly excluded from the regime. Okay? So two of these exclusions, of course, make sense. So when we talk about the public sector directive, and if there's a specific separate defense directive and a separate utilities directive, then defense and utilities have to be expressly excluded from the public sector directive. Yeah, why? Completely justified, because there are specific directives for that. Yeah? But the public sector directive did also exclude certain services, did exclude contracts that are governed by international rules. So here you, for example, have contracts that are awarded, for example, if the World Bank finances a particular project, yeah, then the World Bank will have rules that they want the contracting authority that is using their money. And then there is a conflict rule. It's like, then the directives do not apply. Okay. Or what is this other example? Yes, there are also some weird ones. For example, contracts awarded by troops that are stationed in a member state. Yeah, for example, there are lots of American troops, or there used to be British and French troops stationed in Germany. And when these French and British troops who were covered by the directives, but if they awarded their contracts, if their stationed troops in Germany awarded contracts, they were excluded from the rules. Yes, some of the rules, some of these exceptions are basically completely random. The main message here is to check this as well. First, you check the thresholds, and then you check the exemptions. And there you are, for the thresholds, you can get a bit of a feeling, you know, oh, this contract has this certain value, it's probably in or it's probably out, right? So when you know you've got a construction contract over 20 million, you don't have to check the thresholds again, you know it's in, yeah? But for exceptions, because they can be totally weird, yeah, you have to double check. There are also exceptions relating to national security, to secrecy, yeah, and all these. And anyway, I'm just talking about the public sector directive here. Most procurement laws, for example, or many procurement laws, have the decision like when it's awarded by the Ministry of Defense, then the rules don't apply. Why? Because that's not really like a normal procurement contract, so they argue. I think it is, but it's not a normal procurement contract. This is all about secrecy and national security. Therefore, you cannot really advertise contracts and follow competitive procurement procedures. Yeah? Or you could even include your entire police force in that. Or you could take the decision of excluding your National Health Service from this for whatever reason. Yeah, so exceptions are completely up to you. It's a political decision. But in the EU, where the rules have to be the same, if an exception is to apply, it has to come from the directive. A member state cannot invent new exceptions in addition to this, because otherwise it would be very easy to just avoid the application of the directive. This is the legal problem. Totally legal. Completely a legal battleground. And it might not affect your particular project at all. But then it might. because then you have to develop this fantastic system based on the directive whereby you can actually make sustainable procurement happen. And then there are so many of these contracts to which this would apply that are actually below the thresholds or that are expressly exempt. Okay, right. Thank you very much.